You're listening to FairPlay on justicenews.net.
Welcome to FairPlay. I'm your host, Imran Siddiqui. And joining me today to speak about the National Registry of Exonerations is Barbara O'Brien. Barbara is a professor at the Michigan State University College of Law, where she teaches classes in criminal law and procedure. She's currently the editor of the National Registry of Exonerations, which collects, analyzes, and disseminates information about all known exonerations of innocent criminal defendants in the United States from 1989 to the present. Welcome to the show, Barbara, and thank you so much for your time.
Well, thank you for having me.
So whose idea was this?
The two founders of the registry was Sam Gross, is a professor at University of Michigan School of Law, and Rob Warden, who is at Northwestern, or was at Northwestern. They had done a lot of work looking at false convictions and realized that there was, if you're interested in this topic, it would be really helpful to have some source that is dedicated to documenting these cases when we learn about them, because an exoneration is a big deal and we should be keeping track of when they happen. But there was no single repository of all these cases. So there were lists out there. For instance, the Death Penalty Information Center has one. The Innocence Project maintained one, but there was no central source that kept track of this. So they started the National Registry of Exonerations, and then it sort of evolved and grown over the last several years to be what it is today.
And how many people do you think have been exonerated since then?
Oh, that's a good question. I have to say, so as of today, we have 2,779 exonerations since 1989. I think when they first launched it, it may have been, I believe it was under 1,000. I think it was something like 700 or 800 cases.
Wow.
So that was in 2012. Now, a lot actually of the exonerations that we've added to the registry since then had occurred before the founding of the registry. We just hadn't learned about them. We're always adding old cases that we learn about. We might learn of a case where somebody was exonerated in 1991 and we add it to the registry. So, a good chunk of those additional about 2,000 cases were cases that they had been exonerations before the founding of the registry. But a lot of them are new. I mean, we do see, in a typical year, we might have 120 130 exonerations that take place in a given year. And that doesn't include the older ones that we find out about.
That's beautiful. I mean, the work that you guys are doing with this registry is phenomenal, because without this, most of the masses would never have found out what is going on.
I think that the issue of wrongful convictions has really come into the spotlight in recent years, and I think that really did start with. There have been scholars who have studied this for years, but in terms of capturing the sort of the public's attention, I really think that when we had in the 90s, when we started to see the late 80s, early 90s, we started to see these DNA exonerations when we had this new technology that we could go back and re-examine old cases. That sort of opened people's eyes to the fact that this is not as rare as perhaps we were led to believe. And it's so important, not only for those particular cases, right? I mean, those particular defendants, it's incredibly important to get justice for them, but also, even in cases where DNA can't clear somebody, right? It's just not that type of case. It's not a kind of case where the perpetrator is going to leave behind biological evidence to test. The fact that we can see these very clear cases of errors in these DNA cases, I think opens people's eyes to think, well, what else are we getting wrong? What about the cases where there is no DNA to test, but there's all sorts of other problems with the case that, if we're making mistakes in those cases, maybe we're making them in these too. And so I think that those types of cases, and then also we're also seeing, I think, more nuanced representations of the criminal justice system in popular culture. But what was really sort of lacking in popular culture was not just sort of like look at this terrible criminal and what they did and how they're going to get away with it, but actually looking at these miscarriages of justice. And we see things like, podcasts like Serial or In the Dark, Undisclosed. I mean, these are really popular podcasts that people are listening to, where they're examining these wrongful conviction cases, or what many believe are wrongful conviction cases. And it's, I think it's getting the public more engaged in a way that they perhaps weren't before.
Out of the 2.2 million people incarcerated in our prison systems, how many do you think are innocent?
That is $1 million question. And my strong belief is that it's many, many more than we would like to believe. But is it 1%, 5%, 10%? I have no way to know. And the reason that, we document exonerations, and we are always really careful to point out that it's an exoneration. So a false conviction happens, and that person may or may not be exonerated. But we only know about the cases where the person is exonerated, right? Like, we know that there are people in prison who are as innocent as the people on the registry who haven't been exonerated yet, may never be exonerated for lots of reasons. So we really do believe that the registry numbers are a severe undercount of the actual numbers of innocent people who've been convicted of crimes. Can we extrapolate and estimate? It's something that people who study this really have to grapple with. And I think really the best I can say about that is that the exonerees represent only a fraction of the innocent people who've been convicted of crime.
Wow. Would you agree that maybe this is the time to start working on an innocence list, to at least start collecting data on those who are claiming to be innocent with clear evidence and hard facts?
Yeah, a lot goes into these sort of considerations about who we list on the registry. And it's very important, we believe, those of us who work on the registry, that the registry be a very sort of transparent and sort of actually small c conservative type of resource, in that I have seen lots of cases just in my own work and teaching and then reading about these things. I mean, there's lots of cases out there where I think this person is likely innocent, and I think personally they're innocent. But the National Registry of Exonerations, because we really do want to be the most trusted source on this, we don't make those decisions, right? Like, we don't look at a case and say, well, I think this guy's innocent, so I'm going to put him on the registry. Or, sometimes you might get a case where the person qualifies for the registry, but you think, well, I don't know if I'm not so sure about this case, right? Well, we don't make those calls. So if somebody meets the criteria of being exonerated, that's a legal event, right?
Yep. Like,
that is something that happens either through their governor or a court or jury. These are things that we can say, it's not us. We're not saying this person is not guilty. We're showing you how the process has done this. And it's so hard to get exonerated that we feel that, because once you're convicted, it's actually really hard to get that undone, especially on a claim of innocence. And so the fact that a person who's been convicted can ultimately meet those criteria, we think is a really good proxy for innocence. Of course, we don't know 100% of the time. We suspect there's a lot of people who should be on the registry that aren't, because they don't meet those legal criteria. So, for instance, if somebody suppose somebody's convicted of a crime, and then later it comes out that the prosecution did not disclose evidence they were supposed to disclose, and the person is awarded a new trial, and maybe they take a plea, right? They get something, maybe an offer to plea for time served, or they enter an Alford plea where you're not admitting guilt. Like, those people could very well be innocent, and it's a totally rational decision for them to say, I'm not going to take my chances that the system has already done me wrong. Why should I trust it's going to work better this time? I just want to get out and start living my life. So they take a plea.
Yep.
And those cases don't go on the registry because they're they don't meet the criteria. But we know that there's lots of people who have entered Alford pleas or taken a plea deal after, getting a new trial awarded that really do belong on the registry if the system works better. But we don't want to be engaged sort of from where we are looking at a case and saying, well, I think this person's innocent or I think this person's not, and having that go into it. So everything we do is based on public information. It's all transparent. If somebody writes to us, say, why did you put this guy on here? I don't think he's innocent. We can share with them the documents on which we based it, our criteria for inclusion in the registry, so that it's never like just trust us, because why should somebody trust us? What do we know?
You're listening to Fair Play, the official podcast of justicenews.net. This is Fair Play on justicenews.net.
Welcome back to Fair Play. This is Imran Siddiqui. Today we're speaking with Barbara O'Brien, who is a professor at the Michigan State University College of Law, where she teaches classes in criminal law and procedure, and she's also the editor of the National Registry of Exonerations. How has been your experience meeting or speaking or interacting with an exoneree?
A lot of exonerees, they're all different types of people and they have all different kinds of experience. And some really do struggle upon release, and it's totally understandable. And others are just really want to channel their energy into preventing this from ever happening to anyone else and really telling their story. And, there's all kinds of different experiences and people in different parts of the process for themselves, right? Depending on how long ago they were released, how much time they had served wrongfully. It can be extremely heart-wrenching, but also really inspiring to meet the people behind the stories that we write about.
Some of the exonerees that I've come across, I was stunned that I didn't find any anger or animosity in them.
That is kind of remarkable. There must be, right? We're at almost 2,800 exonerees, and there's going to be a whole variety of reactions. But I would expect, most of them at least would be really angry. And it is remarkable how at least the ones I've interacted with are just like, they just don't want to waste time with that, right? Like, they spent so many years fighting to be released and have their freedom. And you would think, oh gosh, I'd be so mad, I could never get over it. And I just feel like they probably had to really cultivate just such resilience and inner strength to survive that ordeal. It is remarkable how the ones that I've spoken with do seem just genuinely ready to move on with their lives, but at the same time really committed. A lot of them are very committed to not, sort of forgive but don't forget, right? Creating a system where there's, a genuine accountability for the kinds of errors that put them through such a horrible experience.
That is true, because I had a chance to speak to some individuals who are still in prison, and they have been claiming innocence for 3 decades or maybe more, which is like mind-blowing that this guy has been claiming, and these guys have been offered plea deals, and they never took it. And it just blows my mind to see that it is so easy to wrongfully incarcerate someone in America, but it's so difficult to help them get out.
I agree. Our system is set up in such a way that we know once you're convicted, your presumption of innocence goes away, and people think that, it's okay because they have an appeal. Well, forget the fact that appeals take a long time, and we're talking about somebody in being sent to prison while their appeal is pending, and that's in and of itself horrible, but also that's just not how direct appeals in our system are designed to work. They're really, direct appeals are, right after you're convicted, you have the right to an appeal in all the different jurisdictions, and they're really designed to fix legal errors. Like, did the judge wrongfully allow certain evidence to come in, or did the judge give the right jury instruction? But if it's a factual error, right? Like, you could have a case with no legal errors, right? It's just, witnesses say, that's the guy, I saw him, right? I saw him commit this crime, and they could be totally wrong. And if the jury believes them, that's it, right? Like, that's not something the appellate court is designed to fix. So it's incredibly difficult. You also only have the right to an attorney on your first appeal. You're not entitled to an attorney everywhere after that process. And, as a former appellate attorney myself, I can tell you that, that's not a situation where you really can bring in new evidence. I mean, there are ways, if you have, say, a witness who recants, or you learn that the prosecution hid evidence, or, something new comes up that calls into question your innocence, you're not necessarily entitled to an attorney to deal with that, because that's not appropriately brought on direct appeal for all sorts of procedural legal reasons. So it is, I agree with you, it's incredibly difficult to undo a wrongful conviction.
But why do you think those prosecutors and judges who know about the wrongful conviction, they don't come forward to address the wrong that they've done?
Well, there's a lot going on with that question. I mean, I could talk for days about that. I mean, so I should be clear, there are plenty of cases where a person is wrongfully convicted and nobody did anything wrong, right? Like, eyewitnesses say, this is the person who did it. Like, they see a lineup, they pick the person, and then the way human memory works is that can often then they become sort of more sure as time goes on, and maybe there was no tampering with the witness. Maybe everybody thought everything was above board. In those cases, it seems like there shouldn't be a whole lot of ego on the line, but I think there's just a human tendency to to not want to admit errors. So even if you didn't do anything wrong, the fact that you were the prosecutor, you were the judge, that, there's a sense of responsibility, I think that can be really painful to face that, right? Even if you didn't intend to do any wrong, even if you thought you were doing things by the book, the idea that you contributed to this travesty of justice, I can understand that there's some sort of human like just normal psychological resistance to that. In terms of wrongdoing, I mean, then there's lots of reasons why people would want to cover up their wrongdoing. I mean, it's, everything from they're bad, right? They're just sinister, or they don't see what they did as being wrong. They don't believe that the person is actually innocent. They think that it's just, that they're somehow manipulating the system. I mean, all these stakes are really, really high. So on one hand, you think everybody would sort of be able to put their own sort of egos, or these cases can be complex, and I think it's just easier sometimes to tell yourself that you didn't do anything wrong. Now, that said, the registry put out a report this past fall on government officials who commit misconduct, and misconduct is incredibly prevalent in the cases on the registry, and that can range from things like not disclosing that you made a deal with a witness on their own case to testify against your defendant, like that's misconduct. Tampering with manipulating a witness is misconduct. There's cases of forensic misconduct. There's all different kinds, and we see it really, really high rates of it in the cases that result in exoneration. So it is a very troubling pattern, and there's just not really much of a system of accountability for that. It's really unusual to find a case where an official who engages in misconduct actually faces real consequences for it, and I think that's a problem.
Do you think I'd be correct to say that one of the biggest democracies of the world that hold the flag of justice has a criminal justice system which is unjust?
I think you'd be in good company saying that. I mean, we have, we're doing something wrong, right? Because our incarceration rates are so incredibly high, and it's not like, it's working, we don't have any crime. There's so many different forces that go into that, right? There's a whole economic system behind the prison system, and keeping those prison beds full. It just reminds me of recently New York had passed some cash bail reform, And I was just, looking at the newspaper, and I see this article that took place in my hometown. It's in upstate New York. It's a really small town. And it was an article about how since the cash bail reform had come, that they couldn't fill the beds, like the jails were not nearly as full. And I thought, oh, this is a feel-good story. And then I was reading, it's actually, no, this is a crisis for the county because they really need to keep those beds full to get money from some government agency, and now they don't know how they're going to, pay for this or that. Or you think about bail bondsmen, right? That they, the ones who make the money. So your brother gets arrested, and you go to the bail bondsman, and you arrange for them to bail him out, and so they get a cut of that. There's so many systems that are in place that it's going to be that facilitate incarceration, that I think that any movement to push back on that, we just have to expect a lot of resistance.
This is Fair Play on justicenews.net. This is Fair Play on justicenews.net.
Welcome back to Fair Play. This is Imran Siddiqui, and today we're speaking with Barbara O'Brien, who is a professor at the Michigan State University College of Law, where she teaches classes in criminal law and procedure, and she's also the editor of the National Registry of Exonerations. One thing I wanted to ask you, and I think that's a part of what you do, is how can we, if there is a possibility, to predict false conviction?
We do in the registry, not only do we provide a narrative for each of the exonerations, we also do, we kind of code them for certain factors. So we have a database that you can search that shows, what kinds of crimes are they? What was the year it happened? What were certain factors associated with it? Was there a false confession? Was there perjury? We're always a little bit careful about saying that, these factors, mistaken witness identification, false confession, all these things are predictors of a false conviction. I'm like, yeah, of course they are, right? Like if it wasn't a mistaken identification, we wouldn't have had a wrongful conviction. But again, what I always have to remind people is that we have exonerations as our best proxy for false convictions. So we don't know what we don't know, right? So the cases that have, say, some sort of official misconduct, maybe hiding evidence, the only reason they're an exoneration is because that somehow against the odds came to light. So it's really hard to sort of say, looking at all criminal cases, what are the best predictors? I can theorize, and I would say I think cash bail. So the fact that somebody who is if you look at the registry, you would think that all the crimes they're all these serious felonies, right? Because that's what are overrepresented among exonerations. We do have cases of misdemeanors or low-level felonies, but if you actually look at the criminal justice system as a whole, misdemeanor prosecutions are a huge component of all the criminal cases in the United States. And so, you have somebody who's charged with a misdemeanor, maybe they have a prior, maybe they don't, and they can't make bail, so that people plead guilty just to get out of jail.
Wow.
So when people are charged with a misdemeanor or a low-level felony, and they're given an offer to plead, and they can get out of jail, and they can get back to their kids, they can get back to their job that they're worried they're going to lose, they're going to plead to something they didn't do. We know that happens. We have instances of that in the registry.
Wow.
But one can only imagine how often that's going on, and it never leads to an exoneration.
Wow.
Right? We'll never know because people aren't paying attention. Somebody serves 10 days in jail for a minor drug offense. They didn't do it. It wasn't their drugs, or it wasn't even drugs at all. And it's never going to be discovered because who's going to take that case, right? They don't have the resources to go and clear their name. They're going to try to get on with their life. I think that's a big risk. The use really onerous pretrial conditions can be a huge risk factor for false convictions. I think that, anytime that the defense is overworked and under-resourced, that's going to increase the risk of false convictions, either through false guilty pleas or just for poor trial performance. And then, there's incentive structures in place to use, say, jailhouse informants. Or we don't have great accountability mechanisms. If somebody fails to turn over evidence that they're supposed to, they probably won't get caught. And if they do, probably nothing will happen. So there's a lot of things, I think, that, that speak to sort of all aspects of the criminal justice system that also increase the risk of a false conviction.
How critical do you think is to select a fair and impartial jury, and does that happen? And what kind of role do you think race plays in jury selection?
Okay, well, that's an interesting question, because that's my other line of research, is race and jury selection. So I have a lot of thoughts about that. Well, I think we do need to acknowledge the fact that 90 some odd % of cases, convictions are through guilty pleas. So juries are the exception as opposed to the rule. And even in cases that do go to trial, it's not that uncommon to have a bench trial. My own and colleagues' research has shown that race is a significant factor in jury selection. It has problems in terms of creating the jury pool, sort of who's summoned for jury service. And then in the exercise of peremptory strike, so the parties can, when you're selecting a jury, you have sort of a certain number of like freebies, right, where you could just excuse a juror, you could strike the juror using a peremptory strike. You don't have to give a justification. Although the only thing you're not supposed to do is strike based on race or gender. But I think that this is pretty non-controversial to say that it's really easy to get around that rule. And certainly in my research with a colleague of mine, looking at jury selection in capital cases, race is a huge factor, and it's pernicious, and it's very stereotype driven, and it's a separate wrong apart from the accuracy of the proceedings, right? Like regardless of whether the defendant is actually guilty of what he's charged with or innocent of it, it's still a wrong, right? And it's a wrong that's done to the people who show up for jury service or being good citizens, and then are being based on bias and stereotypes and prejudice. They're being told they're not wanted, and that has a substantial cost, I think, to those jurors and to the integrity of the system as a whole. Now, I should point out, I always think of my research, I do false convictions, but then I also do the jury selection stuff, and I've never really seen them intersect until the case of Curtis Flowers. I don't know if you're familiar with his case.
No, I'm not.
Oh, well, I think if you're not, you'd be really interested in reading about his case, and I think your listeners would be as well. He was the subject of a really well done podcast, In the Dark, a few years ago.
You can give us a little quick background about it.
Sure. So Curtis Flowers is a black man who was convicted of a quadruple murder in his small Mississippi town, and on very, very flimsy evidence. And he had a total of 6 trials, and several of which ended in a hung jury. The others resulted in a conviction and a death sentence, but there were reversals. The Mississippi Supreme Court had reversed based on prosecutorial misconduct, and also part of that prosecutorial misconduct was striking black jurors excessively. It's a very segregated community, but I think my recollection is it's about 50-50 white people and black people. And the strike, he was using all of his strikes to get rid of the black people, and eventually went to the United States Supreme Court, which said, no, you can't do this anymore. Like, we're serious about this. You cannot. This is just sort of flagrant racism in jury selection. They awarded him a new trial, so it would have been his 7th trial, and finally the Attorney General's office had stepped in the state, and I guess the prosecutor who had tried him those first 6 times agreed to let the Attorney General's office of the state take over, and they dismissed the charges, because along the way it wasn't just about the jury selection. It was witnesses who were being pressured to say certain things, witnesses then recanting at the next trial, jailhouse informants who admitted they lied to get benefits that hadn't been revealed to them. I mean, there's just this long, sordid history. And this is a case where the racism against the potential jury members really was, I think, designed to sort of harness racism against this defendant. Because the town was so split in public opinion about his guilt or innocence, and it was split along racial lines, So, usually I think of the race and jury selection as sort of separate and apart from the accuracy of the outcome, in the sense whether, did the jury get it right or not. But in this case, they were so close, they were so intertwined that keeping Black jurors off that jury was like part of the prosecution strategy to convict this person in the face of really just the evidence just from one trial to the next just was like shifting and changing and would have given anybody pause.
Wow.
He's truly free now. He's out of Parchment Prison, he's off the death row, and he's living his life.
This is Fair Play on justicenews.net. This is Fair Play on justicenews.net.
Welcome back to Fair Play. This is Imran Siddiqui. Today we're speaking with Barbara O'Brien, who is a professor at the Michigan State University College of Law, where she teaches classes in criminal law and procedure, and she's also the editor of the National Registry of Exonerations. In the absence of DNA evidence, how does one handle false eyewitness testimony? And then, especially when it's intersecting with a lying informant, a lying jailhouse informant. How does one handle something like this?
There's a misconception, I think, that a lot of people have that exoneration means that there was DNA testing, and it's actually the case that DNA exonerations are, an important part of the our archive of exonerations, but it's a minority of cases. Most of the exonerations we see do not have any new DNA testing. Getting an exoneration through DNA testing is no picnic, right? Like, you've got to find the evidence that was used. It was 25 years old, and it's sitting in a box in some evidence room, and you've got to, get access to it, and you've got to get it tested, and everybody's got to agree. So that's certainly not to say it's easy to get a DNA exoneration, but it's usually a little bit more clear-cut once you've gotten to that point. But when you have cases where you don't have that, or maybe there's DNA testing, but it's not really the whole ball game, it might be there's some piece of evidence that was tested and it doesn't really tell you one way or the other. It kind of, leans in one direction, but it's not dispositive. You need, and this is the heartbreaking thing, is that it's so important to have an advocate on the outside with resources to work on your behalf, to get the affidavits from recanting, to find the witnesses, just to interview them, to see if their story is the same, to get, persuade them to give an affidavit. Maybe some people are afraid. They're saying, yeah, I lied because the cop threatened me, but I don't want to go on record saying that because then they're going to know I committed perjury. So it takes a lot of expertise and resources to reinvestigate these cases. And that's why, innocence organizations, so like a lot of, innocence organizations might be like a nonprofit law firm that focuses on false conviction cases, or it's a part like a clinic in a law school where students can sort of learn how to do this kind of work under the supervision of a licensed attorney. And also what we've seen is, and I think this is a really exciting trend, I don't think it's going to fix the problem, but it's important. It's an important development, is the creation of conviction integrity units. Sometimes they're called conviction review units, or CIUs. And these are, distinct, like separate divisions within a prosecutor's office that are tasked with reinvestigating cases when there are credible claims of innocence. And
Virginia just launched one.
Right, they have a statewide, and that's actually really interesting because the CIUs that they are only about 10 years old or so, and there was a couple of like big metropolitan offices that opened them, like Dallas, Texas, and Harris County, and then now more and more prosecutors are opening them in their counties. But it's also one thing we're seeing that I think could be really, really good is these statewide offices, because if you're the Philadelphia DA and you're the Cook County and Chicago DA, like, you've got a lot of attorneys working for you, you have a lot of cases. But if you're a small office with just a handful of prosecuting attorneys, you don't have the resources to create a separate unit that's independent and it just doesn't make sense in those situations. You're not, you're maybe a 5-attorney shop, and of course you're not going to dedicate somebody entirely to that job. They've got lots of cases to do. So I think what these statewide offices can do, because Pennsylvania has one, there are a few others, that it can maybe pick up the slack in some of these smaller counties that really do. Maybe there's a prosecutor who really does want a case to be looked at again, but they don't have the resources to do it, or there's a conflict of interest with them doing it. And it kind of allows for that sort of an economy of scale, right? That they can pick up the slack when you have a smaller or mid-sized office that doesn't have the capacity to have its own conviction integrity unit.
How can we reform the criminal justice system to reduce, if not completely eliminate, these tragic errors of judgment in the future?
So, well, that's a very big question. And, any human system is going to create errors. Like that, I mean, absolutely, 100%. But I mean, we have to treat wrongful convictions the way we would treat any sort of catastrophic event. So, I mean, flying is very safe, and it's safer than it's ever been. And yet, part of the reason is, when there's a plane crash, there is a very deep investigation into what went wrong. It's not necessarily about finding a villain or blaming somebody, but it's about finding out what went wrong, and that can lead to improvements to prevent the same kind of catastrophe from happening again. So if these exonerations are just treated as sort of like a one-off event, and we fix the problem, it's fine, then you can't learn from those mistakes. So we really do need to be treating exonerations as there are case studies in what went wrong. And I am more optimistic than I've been in the past. And I think part of it has to do with, I do see sort of a shift in people's views on this, right? That if you look at what true crime used to be, it used to just be about here's a serial killer and what a monster. And now you see all these true crime things that are this for popular consumption that are about a possible wrongful conviction. And there's an appetite for progressive prosecutors who genuinely want to create systems that prevent these kind of errors, and who are willing to go back and look at prior convictions to see if there were mistakes made. But, I also think that part of the problem, and again, this all kind of relates to that, I don't think of false convictions as some sort of a niche problem. I see it as, part of this entire system that we've created. And, if we have so much criminalization and so many people being shuffled through the system, we're going to be less accurate, right? We don't have the kind of attention that we would need to figure out what happened here. What are some plausible other explanations? The resources to let the defense be able to investigate or to hire experts, because there's just such a volume of cases. There's just so many people coming in and out of the system all the time. If you spend any time in a criminal court in any sort of, even in a moderate-sized city, let alone a big city, it's like an assembly line. And we're going to make more mistakes if we don't slow down.
That's a great point. Because, we have people exonerated, they come out, everyone's happy, we talk about it, and then it's just gone on under the rug. And then people just forget about it. But what you're saying is that each exoneration should be looked at with a microscope to find out where we messed up within the system.
Right. And I think about this in terms of how hospitals have dealt with, I'm this is certainly outside of my area of expertise, but my understanding is that, in recent years, the last few decades, hospitals have really sort of changed how they've approached mistakes. Right, where they've sort of taken more of the approach that the FAA takes when there's an accident with an airplane, right? And creating systems, checklists and systems like safety nets and things like that, because they looked at it as I'm not saying that when somebody breaks the rules in the sense, if police or prosecutors or forensic analysts is engaged in misconduct, there has to be accountability for that. This isn't just forgive and forget, right? That's an important piece of the equation. But you don't necessarily. But at the same time, we can look at every case of wrongful conviction through the lens of, without necessarily trying to assign blame, figure out where the system fell apart. Like where did the cascade of events begin that led to this catastrophe? And then if there are people along the way who did things that require accountability from them, then absolutely, right? It's not about, let's just assume the best of everyone, because I think a huge part of the problem is that we don't have good systems of accountability for our officials. But it's not an either or, right? It's not simply just let's figure out what happened and not blame anyone or blame the villain.
Do you think the registry has been successful in making police officers, prosecutors, defense attorneys, and judges more sensitive to the problem of wrongful conviction?
I really like to think so. And I mean, I do see some evidence of it. I know that our statistics are used quite a bit when people are lobbying for policy changes. For instance, providing a statutory compensation for exonerees. Just last month, or maybe it was 2 months ago, one of our reports was cited in an Ohio case that ordered new trials for 2 defendants who had been claiming their innocence. I do know that some more progressive prosecutors, when they're creating their conviction integrity unit, so for instance, the new prosecutor in LA County in California, is pointing to, in creating the conviction integrity unit or revamping the one they had, they're looking to some of our reports about conviction integrity units, what makes them work well, what makes them stronger, some stronger than others. I do think that we are part of a system of, with Innocence Network, the Innocence Project, and others. I don't want to leave anyone out, but I do feel like we are sort of part of a bigger systemic effort to let people just see that these are not anomalies. That this is, I don't want to say it's a feature, not a bug, but I'm sort of tempted to say it's a feature, not a bug. It's that, that we have false convictions, because obviously nobody's setting out to have a false conviction, but it's far too common to claim that they're an anomaly.
When it comes to reconsidering the guilt of a defendant, who's already been convicted, but new evidence of innocence has come to light, and it's hard evidence. You can't run away from it. But yet, people still have a difficult time to reconsider the guilt of this defendant. Mm-hmm. Why do you think that is? Well,
I mean, sometimes, sometimes the new evidence of innocence is like just, absolutely incontrovertible, but it's often more ambiguous than that. And so it allows for interpretation, right? You could say, well, maybe this recanting witness is lying now because of whatever reason, or yeah, okay, so this witness had a deal and they never disclosed it, but there's still this other evidence, right? So as long as there's some ambiguity, there's going to be room to sort of spin your own story. And it's hard to admit the system made a mistake. And often if it's a case, sometimes there's plenty of cases in the registry where there was no culprit, right? Like no crime happened. For instance, an arson, a case that was prosecuted as an arson, but it turned out it was an electrical fire, right? But often there is a perpetrator out there. Like somebody actually did do this, and sort of admitting that we got the wrong person, and now it's going to be impossible to catch the person who actually did it. There's a lot of motivation to think you got it right the first time.
What would you say to an average person like me, for example, listening to you and just discovering about this exoneration list and about the whole concept of exonerations? What role can an average person play in this whole process?
I think, the more you educate yourself, we have a lot of resources and links to other resources that you can find to learn about it. And then I would say, be an informed voter. Local elections matter a lot. Like the state legislature, they're passing the laws that are being used to convict people, and for better or worse, right? They're setting the budgets for indigent defense. Local prosecutor elections are incredibly important, and we're seeing, I think, at least in some pretty big metropolitan areas, the electorate getting a lot more engaged and really thinking, not just sort of going with the whole law and order mentality, but wanting somebody who's a little bit more nuanced, a little bit more holistic in their approach. So all these things are happening at the local level. It's a National Registry of Exonerations, but these are cases that are, happening in some, in a county courthouse, and by the decisions of the elected prosecutor, and how the defense is funded, that can turn a lot on, local appropriations. And so really, I think, engaging with this on a local level, I think can be a lot more powerful than people realize.
This is Fair Play on justicenews.net.